Resumed for a second panel. Our witnesses have been asked to make an opening statement of 5 minutes each. This will be followed by questions from senators. With us in person from the Black Opportunity Fund, Craig Wellington, Chief Executive Officer. Next, we welcome from the Black Manitobans Chamber of Commerce, Deborah Zeta Somakoko, President and Founder. I invite Mr. Wellington to make his presentation, followed by Ms. Somakoko. Over to you.
Thank you. Honorable Senators, thank you for the opportunity to address you today. My name is Craig Wellington. I'm the CEO of Black Opportunity Fund. We are a national charitable organization which is dedicated to dismantling the impacts of anti-Black racism and fostering socioeconomic empowerment of Black communities in Canada. We applaud and rise in support of Bill C-9. We commend Parliament's recognition that certain symbols carry such concentrated hate that their public display constitutes not speech but threat. But this bill, as drafted, is incomplete. We are here to urge one essential amendment, which is the inclusion of the noose among Canada's designated hate symbols, acknowledging its historical as well as its widespread current use as a symbol of racial terror in Canada. This recommendation by us is supported by over 420 leaders of Black organizations representing every province in the country that are calling on Parliament to include this amendment in Bill C-9. According to RCMP reports, Black Canadians are consistently the leading target of hate crimes in our country, consistently over time, more than any other group. Yet the bill, as currently crafted, does not acknowledge this reality in any way. We are asking the Senate to address this problematic gap to ensure that all Canadians, including Black Canadians, are protected from hate crimes. We are not asking this committee to silence difficult ideas. We are not asking you to shield Canadians from discomfort or important debate. However, there is a line between discourse that provokes thought and symbols that provoke terror. The noose is not a position in a debate. It is not an argument. It is a promise of violence. It is a threat. It is a tool that is actually being used to commit violence and acts of racial terror. And some may ask, is a noose truly a hate symbol for us in Canada? Is this not an American concern that is imported from their history? But we have our own history with the noose in this country. The noose found victims here in Nova Scotia, in British Columbia, in Quebec, in Ontario, and beyond. But the history of the past alone may not compel you until you understand as well what is happening in the present. Over the past decade, the noose has repeatedly reappeared as a tool of hate and racial intimidation here. During the height of the pandemic, nooses were found hanging at multiple Toronto construction sites, including transit projects, including hospitals and commercial buildings over the course of years. In Nova Scotia, recent reports of nooses have surfaced targeting Black families and communities. In Alberta, an Alberta hospital, a Black surgical assistant was confronted by a noose hung on the door outside the operating room that was specifically put there by a white surgeon to intimidate him. There are many other examples in recent years. These are deliberate acts of hate and racial terror. They are precise in their targeting, deliberate in their effect. They are not ambiguous. The noose requires no words. It makes no explicit threat that might trigger existing criminal provisions. It simply appears on a student's locker, on a car mirror, or hanging from the tree across from the home of a Black family. It says, we don't want you here. It says, remember what was done in the past. We can do it again. This is an explicit promise of violence. Some will say the noose has other meanings. used in contexts unrelated to race, in discussions of suicide, in historical displays or theatrical productions. And this is true, and this is why we trust in the wisdom of our courts and the principle of context. The criminal code already recognizes that symbols derive meaning from circumstance. A noose displayed in a museum exhibit is not the same as a noose hung on a black family's fence or placed in a black child's backpack. The courts can make this distinction. So we're not asking for a blanket prohibition. We are asking that when the noose is deployed as an instrument of racial terror, when its context makes this unmistakable, the law recognizes it for what it is. We also support the creation of an independent mechanism to review and determine if other symbols in the future should be listed as symbols of hate. There must be a high threshold and independent of the whims of future governments. So in summary, we urge this committee to amend the bill and designate the noose as a hate symbol because of its historical and, importantly, current use against Black Canadians and others. The defense of free expression and the prohibition of symbols of hate and terror are, in fact, the same fight. The fight for a Canada where no one is silenced by fear and threats. The fight for a Canada where the noose, at last, is recognized as a threat of racial violence, not history, but a wound that remains open until we choose to close it. Thank you.
Thank you. Well, Ms. Somakoko.
Thank you, Chair. Honorable Senators, thank you. And I thank God for the opportunity to speak before you today. My name is Dr. Deborah Zeta Somakoko, founder and president of the Black Manitoban Chamber of Commerce, Canada's first bilingual Black Chamber of Commerce, and the first Black woman in Canadian history to found the Chamber of Commerce. I'm appearing on behalf of the Black Manitoba Chamber of Commerce, but also on behalf of millions Black Canadians. Further to our written brief submitted to the Standing Committee on Justice and Human Rights regarding Bill C-9 and Canada's urgent need to explicitly recognize and confront anti-Black hate within federal legislation. Today, we come before this committee with a clear message. Black communities in Canada are not asking for special treatment. We are asking for recognition of specific, historic, measurable, and enduring form of harm, anti-Black hate, and for legislation that reflect that reality. The Senate has a unique responsibility not only to review legislation, but to ensure that it reflects the lived realities of all Canadians, including those whose experiences have historically been minimized, dismissed, and overlooked. Honorable Senators, there remain a persistent assumption that existing constitutional and human right protection are already sufficient because they apply broadly to all Canadians. But generalized protection do not automatically produce equal protection in practice. It has not reflected in a case of Black Canadian. Anti-Black hate is not random. It is not isolated. It is not incidental. It is historically rooted, structurally embedded, ideological, measurable, and reproduced across generations. Across societies and continents, we continue to see the same pattern repeated. Black communities are simultaneously copied, feared, mocked, criminalized, fetishized, segregated, underpaid, over-policed, erased, and exploited. These are not isolated incidents. They reflect a global hierarchy that has historically positioned Blackness as inferior. This is not about hierarchy among communities. It is about recognizing that equal protection under law sometimes require explicit recognition of distinct and measurable form of harm. Anti-Black racism in Canada is not only social, it is economic. It is reflected in unequal access to capital, procurement barriers, exclusion from leadership, credibility bias, underrepresentation, and systems that continue to make it harder for Black entrepreneurs and professionals to scale, compete, and succeed. Economic inclusion is not charity. It is economic development, workforce development, innovations policy, and nation building. At the same time, anti-Black racism is sustained not only through institutions, but also through narratives. The repeated vilification of Blackness in media and public discourse continues to associate Black people with danger, criminality, and dysfunctions while minimizing Black excellence, leadership, humanity, and complexity. Media does not simply reflect society, it helps shape it. Black people became the construct, justification used to build empires on stolen land and stolen labor, the imposed bottom caste upon which system of power and wealth are built. Once societies organized themselves around the idea that Blackness means less than, entire social structures learn to define themselves in opposition to it. That is why anti-Black hate persists. It persists even in places that have very few Black people. Canada is not outside this reality. Our own government acknowledges that anti-Black racism is entrenched within Canadian institutions. We see this in rising hate crime, overrepresentation of Black individuals within the justice system, documented racial profiling in policing, economic exclusion, and systemic barriers across employment, housing, healthcare, and education. These are not simply personal experiences or isolated interactions.
Ms. Somakoko,
they are identifiable.
Would you mind summarizing that?
Yes. They are identifiable, measurable, and documented reality. And measurable harms require explicit protection under law. Recent report in Canada has highlighted the growing presence of organized white supremacist extremist network promoting racial conflict, so-called race war. This demonstrates that anti-Black hate is not only systemic, it is organizing, adapting, and becoming increasingly normalized. Canada cannot claim to confront hate while refusing to explicitly name one of its oldest and most persistent form. Anti-Black hate must be explicitly recognized, clearly measured, and directly addressed within Bill C-9, because legislative silence in the face of documented anti-Black harm is not neutrality. It is unequal protection under law. Thank you.